Roger Brock,
Here.
Dean Button,
Here.
Nathaniel Harris, Ann Herbert,
Here.
William Hutton,
Here.
Juan Moreno,
Here.
Kimberly White,
Here.
Thomas White, Janet Benez,
Here.
7 present, we have a quorum.
Thank you. Is there a motion on the floor to approve the minutes of?
Motion to approve minutes for August 15, 2016 minutes.
All in favor?
Aye.
Thank you. We'd like to call petition CP-16-08, petition for Clavin Clifford Incorporated for approval of a 4-lot subdivision known as Olympia Plaza, second addition to the city of Hammond, located at 4141 Calumet Avenue in a C4 district. Have all the notifications been received?
Yes, they have.
Would the petitioner care to come forward, explain your project? Please sign in first.
My name is Chris Moore with Nice Engineering. I'm here with George Loxis to speak on behalf of the plat approval for the Olympia Plaza Second Edition. And we're requesting preliminary and final approval of the plat.
We're ready when you are.
Thank you. We're proposing to make it a 4-lot subdivision that's going to be located on the northeast corner of Calumet Avenue and 141st Street. We're proposing to have utility and ingress-egress easements throughout the property to allow access into the property and to get the utilities to the surrounding, or to lot 1, 2, 3, and 4 at this time.
Is that it?
And the utilities haven't been finalized yet. We're trying to get all the developmental plans completed. We have a preliminary site plan on here that shows a potential for a gas station on the north lot, office buildings on the east, kind of on the southeast corner, and a potential coffee house on the southwest corner. And then the lot 3 is, right now, it's an unknown development.
Thank you.
Would you care to explain the changes that you've made? Because I've handed out to the Plan Commission the revised plat that you provided. Could you tell the Plan Commission what changes on the plat?
Yes. The plan was submitted early on, and it's remaining a 4-lot subdivision. We had adjusted the language for the ingress easement to read, and the information on the plan that you had received is located kind of in the middle of the property, just below the Indiana Toll Road. Everything else remains the same as the original submittal. And the revision is to state that the ingress/egress easements are for the mutual and exclusive benefit of the legal owners of Lot 1, Lot 2, Lot 3, and Lot 4, as depicted within this Olympia Plaza Second Edition for the city of Hammond, Indiana. In parentheses, a re-subdivision of Mobil Oil Corporation subdivision. And further services to allow access and underground utility service. Without limitation, ingress/egress easements shall not be extended to the neighboring parcels in the absence of a subsequent written easement agreement therefore.
Could you address the reason for the change?
The reason was a request from my client to adjust it. After looking at it in a little bit more detail, he requested that we make that revision. Want to elaborate on that, Paul?
Thank you. Commissioners, do any of you have any questions? Any questions?
I saw the original submittal, and now we're seeing a new submittal, so this kind of puts me back a little bit. You're saying the only change is this particular language.
Correct.
Why so restricted? Because it seems to me like we're only allowing access and utility easements to just this particular subdivision.
No, the utilities, this is just, the restriction is revised to be the ingress egress. That's the only restriction.
So does this allow or prevent access to any other adjoining parcels? To the rights of way?
From, across our property, yes.
Quick question for Brian. We can assign addresses as Calumet Avenue for, say, Lot 2. So Lot 2 is this assigned an address of Calumet Avenue, even though it is blocking the frontage to Calumet Avenue from lots 3 and 4?
It is a little unusual to do that. However, if you look at the site plan and see the orientation of the building, the Calumet Avenue address has made the most sense for that purpose. And in doing the numbers, I made sure that the range of Lot 2 is in between the range of Lot 4 and Lot 3.
And we're only asking for plat approval at this time, preliminary plat approval. There'll be a subdivision plan approval at a future time?
No, this is preliminary and final approval of this subdivision plan, not of the site plan.
So the concern the engineering department had on this particular plat is access for truck movements, turn movements onto the site. I discussed that with the concern. The concern was that northbound Calumet Avenue to the site for truck and trailer deliveries
For fuel.
for fuel particularly, requires that the northbound truck be in the left-hand lane when making a right-hand turn on the subject property.
Yes.
We asked that, that this particular, that fuel deliveries be made from the north, so southbound traffic from the north into the lot. So southbound Calumet, left-hand turn into the subdivision, rather than northbound
Correct.
on the left turn lane, because you're making a right turn from the left turn.
Sure, and I added that note to the site plan.
So are we approving this attached site plan? Are we being requested to approve this attached site plan?
No, the site plan is just provided for information purposes so that you understand the relationship between the site plan and how the lots are being divided up.
And the site plan is just to give you an idea what we're thinking. It's not set in stone yet. So we're gonna have to come and get site plan approval, as you know, as prior to getting all the permits for that.
And normally, site plan approval is staff level,
Correct.
except for the gas station being a conditional use permit through the Board of Zoning Appeals.
Correct.
Well, I can say that I'm a little bit concerned about this ingress egress, and so I guess we'll deal with that.
But your concern is more from a site plan perspective as opposed to the way the easement is shown on the plat.
I'm sorry.
Is your concern more from the site plan question, or is it related to the way the easement lines are drawn on the plat?
I'm going back to the first question, that is the ingress egress concern that was brought to us today. The revision to the plat, that's my concern. So the revision of the plat prevents ingress egress to adjoining lots, that was mentioned earlier.
To the neighboring property across our site, just for ingress egress.
But it's not preventing any internal.
No, all internal access is fluent throughout the entire parcel.
That makes sense. I don't have any questions.
Good points, Commissioner Button, and I'd like to add to that, being close to a gas station myself, there are trailers that go across 5 lanes of traffic to gain access into that gas station. So I am concerned, and although we might request or require that it be southbound to turn left as suggested, who's going to monitor that?
That would be something we'd have to look into at that time. I would have to look into that as well.
The other question I have to echo is the 90-foot by the length of your property, piece of property on the far east side, and the accessibility to that property. How are you going to prevent it from being landlocked?
You wanna elaborate on that?
All I can say is currently, I don't have ingress egress rights with any agreements with any of the neighboring parcels, and I don't intend to by making any action tonight or in the future until I could come to an equitable agreement with someone who may want that ingress egress.
Commissioners, any other comments, questions? No other questions? Like to open the floor for public Sorry very much. Staff, please.
Mr. Moore,
Yes, sir.
when you were looking at Lot 2 of the subdivision, did you look at the embankment of 141st Street and its relationship to any NDOT ownership of the embankment?
We did have it, we have a topographic survey of it, and it has the contours on there, and we have that planned in there. We don't have the site plan completed, well, the layout's on there, yes, but we did look at it, yes.
Okay, so, and in your title work search and doing the plat, was there any documentation, or first of all, is there an encroachment of the embankment onto Lot 2? And secondly, is there any documentation from NDOT that had that an easement or anything related to that?
I believe that there is an easement on there, and as for the encroachment onto our Lot 2, I'd have to look at it again to see where those contours end, and it's a grading issue, more so we'd have to match the grading that's on there to make it work. As far as the easement through there, I'd have to look at that to see exactly what was found.
Well, the easement that's depicted, which is 41566 and 9277072, that is based on the document that I received from your office today. That is an easement for a pipeline related to Wolverine Pipeline Company. And so I did not see any language in there that was addressing if NDOT is encroaching upon Lot 2.
I would have to look into that again. I apologize for that. The plat was put together, and I was talking with my surveyor in the office, and I'd have to follow up with him on that.
Mr. Paul, is that item 5? Is that item 5 on the surveyor's report, access to 141st Street is conditional upon approval of the State of Indiana Department of Transportation as described in that book? Is that what you're referring to, that access from through NDOT parcel?
No, actually, I'm not referring to that, and I'm not really sure what that notation means.
And we still have to go through to get a driveway permit from NDOT. We're applying for that as well.
That's on 41.
That's on, it is on 41, and I believe that it's going to come back over on 141st as well.
So we're not certain whether or not there is an NDOT easement on 141st.
I would have to find out again from my surveyor on that to try to make heads or tails of that one. I apologize for that. Because right now, we do have access to 141st Street through an existing driveway, and that's the driveway you're gonna utilize.
You're saying that the easement that you're depicting corresponds to the current curb cut driveway on 141st?
Yes, I'd have to confirm, but I would have to say yes.
I believe that's what our discussions has, but I just wanted that confirmation.
Thank you.
Well, then I have the question, who is responsible for that drive?
For the drive,
Right.
the driveway will still be access out onto 141st Street and out to the right-of-way of 141st Street. So the drive itself on city property is the city drive. And again, I'd have to look at the easement issues to see if it's NDOT responsibility. But it would be, the drive, once we get into our site, would be our responsibility, or my client's responsibility, I'm sorry.
And Mr. Button, I think, our attorney pointed out a notation that I didn't automatically see, but there is a notation on the plat that does refer to that book and page number that you referenced in note number 5. There is a statement on the plat that says it is the state of Indiana right-of-way easement line, so apparently they do have a right-of-way easement there, so I stand corrected on that issue.
Anything else, Mr. Poland?
Not at this time, no.
We'd like to open for public comment, please. Please remember, when you come up, state your name, your address, sign in, please, and a 3-minute time period.
How many?
3.
3 minutes?
3 minutes, after you get there.
I can't even get up there that quick.
And it won't start till you're ready to go.
I'm a little slow here, sir.
That's okay.
The only thing that works good on me is my brain. My name is John Leahy. I developed that whole area over there. I built the mini storage facilities. I own the 90-foot that the gentleman, Pete, is that Pete? Pete, yeah. I can't read that. But anyhow, that you asked about the 90-foot strip over there. I own the 90-foot strip. You also mentioned about the easement going back over there, that is, they want it closed off. Well, they want it closed off so they can squeeze me off as to the part, as much money. If I'm landlocked, they want to steal the property from me. That's why they got it land off. So they want to get it closed, so I can't get in it to develop that piece of property. I really don't want to develop a piece of property. I'd rather sell it to them. But they don't want to pay enough money. I tell you something, I'm going to tell you just, when it came to there was an auction here when Bill McHenry had this. They were at the auction. They bid $500,000 for the piece of property they got right now. Bill McHenry went bankrupt. They bought it at a tax sale for $106,000. Bill McHenry was going to give me $200,000 for the piece of property. So even if they give me $200,000 for my piece of property and developed it, they only got $306,000 in it, and they got the whole 6.5 acres. I mean, how cheap can you get, you know? But that's why they want to cut that easement off, so I can't get into it. I can't put utilities into it if I'm landlocked. The project that they want to put up is fine. I think they're stupid for not buying my piece of property and letting you develop it and get more tax money for putting up more buildings and everything over there. But that's my story. And if they don't want to come up with the money, that's what's going to happen. But I have to have an easement to get to my piece of property so that I could put 11,000 more square feet of building up in that piece of property over there if I have an easement to get it. They can too if they bought it. I mean, they're just being foolish for not buying it, and the city let them do it without getting my piece of property is is foolish because you can get a lot more tax money, more buildings, and you're not crowding everything into everything over there. Yeah.
Thank you very much.
Any questions?
We'll address questions after the public comment has been closed.
Okay.
Thank you. Any other public comments? Any other public comments? Any other public comments? Public comments are closed. Mr. Poland?
As stated, you have a revised copy of the subdivision plat. The only difference being this language associated with the ingress egress easements. And not to put our attorney on the spot, but I also shared this with Mr. Moore this afternoon. I think the way the easement language is written is awkward. I certainly understand the intent of it, and I think that is something that would need further review from our point of view to make the language a little less awkward in its grammatical structure. As far as the staff report's concerned, I'm going to make a revision as I go through the staff report. I think if you still review, if you look at the staff report, as far as the background is concerned, there's no changes being made in the background. The subdivision, in essence, meets the technical requirements of the ordinance. I do see one error that we haven't discussed before that will have to be addressed, another notational error, but that's something that's easily dealt with. The plat has gone out for review from the utilities and the review agencies. We did not receive any objections to that. Therefore, the staff recommends that the Plan Commission grant preliminary and final approval to the revised Olympia Plaza Second Edition subdivision plat, subject to the final resolution of this egress easement language, and there's a technical correction to one of the building setback lines that we would need to work out. If the Plan Commission agrees with this recommendation, staff requests that this revised report is adopted by the Plan Commission as preliminary findings of fact.
Commissioners, are there any questions, comments?
I guess my concern is to not resolve this issue. I mean, it sounds to me that Mr. Poland's suggesting that we do a preliminary and final plat approval and still have this lingering issue hanging that is resolved at a staff level. Is that true?
Yes.
Do we believe that this issue can be resolved in a reasonable amount of time? Mr. Poland?
I believe it could be resolved in a reasonable amount of time. It's however long it takes our attorney and myself to kind of tweak the language, and then of course send it to the petitioner for their confirmation. And hopefully it is something that will be just once rather than a multitude of back and forth, because it's just more of, again, language just seems awkward to me.
Yeah, can I just weigh in? Yeah, and I just want to point out, and I think Brian did a nice job of sort of framing the issue for preliminary and final subdivision approval, which is, does this plat meet the terms of your subdivision control ordinance? his review, everybody's review, in large part, yes, it does. There were two issues that were brought up by the commissioners, and variations between you and Mr. Hutton, but number one was the access in the event of a gas station, and I think that is clearly a site plan issue as opposed to a plat approval issue, okay? And then the second issue, which is this language, and I apologize, but I just saw this language about 5 minutes before the meeting started. I think what Mr. Poland is saying is conceptually and substantively, there's no issue with, that this body, we don't want to interject in a situation between adjoining landowners. There's no issue for us to resolve at this level with regard to that. The issue is that the language appears to be, I may have written it differently, and I'm sure Mr. Moore, was writing it to address an issue that he knew came up, and I'm not being critical of that, but I think with, a little bit of thought, we can keep the concept of what he's looking for, and just kind of change some of the grammar in that additional language. So I really think that's going to be something that's going to be resolved at a staff level in very short order.
Prior to approving this plat, what access does the adjacent property owner have to an existing right of way within the city? Do they enjoy access from an existing right of way?
Go ahead.
Technically speaking, because of the notation of the state of Indiana right-of-way easement line that's referenced there, their property does have, it abuts the right-of-way to access it. From a practical standpoint, and that was one of the reasons for my questions about the slope, I'm a little concerned that whether or not there is physical access for the property owner to properly use the right he has to access the street.
Let me answer from a legal perspective. The plat does nothing to the access that is currently existing. So if there's access now, whether it's a prescriptive right, okay, that's been utilized for 25 years or more, or whether it's straight out the area that Brian's referring to onto 141st Street, that's unchanged. Okay, whether or not it's a prescriptive right is between those two landowners, and if they can't work it out, potentially a court of law to figure out what the deal is there. But the plat itself does nothing to, I don't know enough about the situation to render an opinion on the access that's there now. I can just tell you that this plat doesn't do anything to it.
I'm satisfied with your,
Thank you. Commissioners, any other questions, comments? Hearing none, is there a motion on the floor?
Mr. Chairman, I'd like to make a motion, and help me out if I do this wrong, Brian, but I'd like to make a motion to accept staff's recommendation to approve preliminary and final plat approval for this subdivision,
Subject to,
subject to the review of staff and the alteration of the ingress egress language.
basically revision of the easement language and a building setback plan.
Thank you. Is there a second?
I'll second.
Roll call vote? Yes.
Dave Budden,
Yes.
Nathaniel Harris,
Yes.
Ann Herbert,
Yes.
William Hutton,
Yes.
Juan Moreno,
Yes.
Kimberly White,
Yes.
Janet Banez,
Yes.
8 ayes, 0 nays, 0 abstentions, motion passed.
Thank you very much. Moving on.
Can we just go back quickly to 16.08? You need to adopt if you want, obviously, but the recommendation would be that you adopt Mr. Poland's report as findings of fact for the preliminary and final plat approval.
And it would be the revised report.
I would like to make a motion to accept Mr. Boland's revised report as a finding of fact. Is that correct?
That'll work.
That'll work.
Is there a second?
I'll second it.
Roll call vote?
Martin Rock,
Yes.
Dean Button, Nathaniel Harris,
Yes.
Ann Herbert, William Hutton,
Yes.
Juan Moreno,
Yes.
Kimberly White,
Yes.
Janet Vanez,
Yes.
8 ayes, 0 nays, 0 abstentions, motion passed.
Thank you very much. Moving on, CP-16-09, petition of the Hammond Plan Commission to amend the text of the zoning ordinance to modify provisions for the temporary, which will affect Title 21 signs,
It's,
correct?
I think it's Title 22.
22?
You had trouble with your Roman numerals?
No, the agenda.
The agenda's wrong.
Oh, is it?
Yeah, it says
Oh, okay.
So it is 22?
It is.
That's what I have in my report.
I stand corrected. Mr. Poland, please.
Before you is a text amendment to the sign section. Specifically, it is the section that refers to what we call temporary signs. That is section 21.10, and, I'm sorry, in my copy, the page is missing. Oh, no, it's out of order. It's out of order, thank you, 21.11.
Can we just make that as a point of clarification to the commissioners that the sheets attached to this particular text amendment ordinance are out of order? Do you want to correct your sheet order?
Yeah, the second and third page should be reversed.
So the first sheet should be text amendment zoning ordinance amendment to amend provisions. So that's this one. The second sheet of your package should be the ordinance itself, the first page. The second sheet should start with the number 2, signs placed and marked. That should be the second sheet. The third sheet should be start with the number 8, shall not exceed cumulative area. And the last sheet should begin with the word subsections, paragraphs, sentences.
Thank you, Mr. Button.
Done that earlier, sorry I didn't catch it.
Yeah. So anyway, temporary signs are literally those signs that only show up for a short period of time. They, otherwise, other signs referred to as permanent signs. And our current language is a little unclear, or at least it was one of the important points in our current language was that a temporary sign could exist or be put up with the proper permits, of course, for a 60-day straight period. That was concerning on various levels as to when it comes to certain signs that show up for seasonal activities, and that we talked about that that we want to shorten that period to 30 days, have a 30-day gap where the sign has to be removed, and then it could be another 30 days. It's still a total of 60 days for the calendar year, but it's just to break it up so it's not consecutive 60 days. Some of the other changes, in particular to 21.10, was clarifying some of the
some duplicate language, clarifying the language on that number 2 about parked vehicles or trailers. Number 12 is new language when it talks about the items that are by wind or streamers, those types of things. Those types of signs have a tendency to be distracting and potentially can cause to draw your eyes away from your driving. You know, that they're there to attract your vision. However, that becomes a traffic hazard if you are focused on a whirligig or whatever that seems to be fluttering in the wind. The other important change in here is number 10. Our previous language regarding balloon or inflatable signs did allow them on the ground. About 10 years ago, they used to be allowed on the roofs. We changed the language to get them onto the ground. And now we're at the point where we want them eliminated. Some of the awkwardness of the big balloon signs, when they became on the ground, they started invading required parking spaces and then becoming visual and distracting objects. So the idea is to eliminate those in their entirety. The section 21.11 is probably, there's more significant revisions. It, again, was clarifying the status of the temporary signs, prohibiting them on residential districts, not being illuminated, not in the public right-of-way or parkway. We have occasions where we will see businesses put signs in that area between the curb and the sidewalk. This is just to make it clearer that those are not allowed. I mean, they never really have been allowed, but it's writing the language a little bit more clearly so that code enforcement has a means to address people who put private signs in the public right-of-way. Vision clearance is to make sure, again, from a traffic standpoint, make sure they're not blocking that vision clearance triangle. Setting them back to make sure the setbacks are appropriate. But number 7 is new. We're limiting the size of them to the 32 square feet, making that clear for all of the temporary signs. And number 8 is added so that the calculation that we set up for all signs on a property, in a C4 district, for example, it's based on 2 times the primary frontage dimension of the lot. And that is a number that we work with, that all the signs on that property have to be less than that number. And what this is trying to say is that even the temporary signs have to be less than that number. So we set a cap, and it doesn't really matter to some great extent whether they're permanent or temporary, they have to be under that cap. We also added some new language in section B about A-frame and T-frame signs. We did not have clear language about that in our previous version. Setting a height limit, a square footage limit, and I actually was able to steal a couple of graphics off of somebody else's zoning ordinance, and so we now have graphics in this section. Number 2 is an expansion of the language, just had banner signs, but there's a lot of things that we're starting to see that sometimes they're referred to as banner signs or sometimes referred to as blade signs. There's feather signs. That's where figure T2 comes in for everybody to understand what type of sign we're talking about. And again, height limit and square footage. And then in number 4, we just added the square footage and the height to that section. Do you have any questions about that?
About the entire ordinance, or just that particular?
Okay.
I have questions.
Okay.
Mr. Button? Absolutely.
Will this ordinance require a public hearing at the city council level?
That would be if they choose to. Normally, what happens when something comes from the Planning Commission, we are the body for their public hearing, and they do not normally, as a matter of course, have public hearings for anything that we send them. but it's certainly within their rights to do so if they wished. So, you know, this will only require a legal notice in the paper for our activities, but technically we're supposed to we'll go through the public hearing motions. Tonight.
Now,
Tonight, we'll have a public hearing
Yeah.
on this particular topic. So it meets the rules of having a public hearing. Thank you. In all seriousness, with regard to the prohibited signs, item 10, balloon and inflatable, how does this affect, labor unrest style inflatable balloons? Are they prohibited then from
Well,
doing this as a result of this action?
my answer, subject to the attorney correcting me, because I'm going to pretend to be an attorney, is that I think recently there was a court ruling, and I think it was in Wisconsin? Arizona, thank you. Well, I'm not referring to the Arizona one.
Oh, you're not.
There was another one
okay.
that specifically talked about the labor unrest rats, and that is a balloon sign, and the particular community, I think, had a ban on them. But that particular court ruling stated that because that's a First Amendment right, that First Amendment right would supersede the prohibition of the balloon signs because it was the nature of that particular shape of that balloon because of what its purpose was, and that's a layman's understanding of the court ruling.
It is, and that's one court's interpretation of that. I would tell you that when you have, the problem you have with these ordinances is that if I have to look at what the balloon says to determine whether it's in or out, that's called a content-based restriction, and that's a problem. Okay, so right now, you're not discriminating based on the content of what's on the balloon, whether it's a balloon rat or a balloon for sale sign. So right now, but then it's going to come up, you know, Mr. Poland's right, it's a First Amendment issue. How far is the city going to push that? That's going to come back to an issue, you know, of code enforcement and the administration. How far are they going to? I think you're well served to ban them without relation to the content of what's in or on or the shape of the balloon. And then you're going to have to potentially make a determination at that time.
Section 2111, temporary signs, you indicated that the sign holder is allowed to erect a temporary sign for 30 days, must remove it for 30 days, and then has an opportunity to re-erect for another 30 days for a total of 60 days. Is there a process which they would come and ask for a variance to that, where they could leave their sign up for longer than 30 days, but not exceeding 60 days?
Anything within the zoning ordinance, they could ask for a variance. It would be probably a developmental, a time frame would be a developmental variance. But when you're talking about a 45-day process at least to get through the Board of Zoning Appeals, I don't know, practically speaking, if that is going to occur. But theoretically, yes, they could.
But there is a way to
Yeah.
ask for a variance.
Yeah, there's always that catch-all zoning relief aspect.
And that applies to these A-frame, T-frame signs. When you see these A-frame, T-frame signs along Calumet Avenue, they're only allowed to be up for a period of 30 days at a time, and then be removed, and then allowed for another 30 days.
Right. I mean, obviously from what we're doing here is we're setting the rules. The actual enforcement of the rules would be a code enforcement question. Even if with a temporary sign, you still need an improvement location permit. You know, there may be situations where people don't know they need to get one. So that again, that's a code enforcement issue.
Okay. Thank you. That's all the questions I have.
And code enforcement is in agreement with this.
I have forwarded it to their administrator or whatever their the title that Jaime is, but he has seen it, and we've had some discussions internally that, you know, once we get this in place, we'll go back and work with them about how they're gonna enforce it.
I have a question about the 60 days. It's a total of 60 days for one entire year. Can it be 5 days at a time, 30 days off, 5 days at a time, or is it 30 on, 30 off?
The wording, and
I didn't read it, I apologize.
you didn't read my ordinance?
I just looked at the pictures. That's all I care about.
I'm sorry, I'm trying to find that section.
It's, the second page of the ordinance, page 2 of the ordinance. Section 21.11, temporary signs. Except as provided herein, temporary signs are permitted for a period of 60 calendar days per calendar year. A temporary sign may be allowed for an initial period not to exceed 30 consecutive calendar days, at which time the temporary sign shall be removed. The second period not to exceed 30 consecutive days may be allowed after a period of 30 consecutive days has expired.
So if someone wanted to put this, they have up to 30 days. If they choose to do less than 30 days, remove the sign, they would still have to wait 30 days.
Right.
And then they would have the opportunity of up to 30 more days. It's not like you're banking the days that you didn't use in the first period.
Got it. Understand. And the last question that I have is, you talked something about trailers or vehicles that have signage on it?
Yeah, that's number 2 at the top of that page.
Right. Can you give us a little more?
Well, what seems to be happening, you know, you have to make the distinction between a business that has a vehicle with their business information on it, but it drives around and it just parks occasionally, you know, at the business, as opposed to what we're seeing, or in some of the research, is that people will park a semi-trailer on their property, and it is painted to be a sign.
Got it.
And so it becomes a non-movable thing.
Thank you very much. Commissioners, any other questions, comments? We have to open this to the public.
You do.
Yes.
We would like to open this to the general public. Is there anybody in the public that would like to speak? Any public comment? Any public comment? Public comment is closed. Brian, any other comments you wish to contribute?
No.
Thank you very much. Commissioners, any other questions? Roll call vote.
Oh, well, I'm sorry.
I'd like to make a motion to accept staff's report and it be adopted by the commission as a final effect.
Is there a second? Thank you. Roll call vote.
Roger Brock,
Yes.
Dean Button,
Yes.
Nathaniel Harris,
Yes.
Ann Herbert. Yes. William Hutton.
Yes.
Juan Moreno,
Yes.
Kimberly White,
Yes.
Janet Vanez.
Yes.
8 ayes, 0 nays, 0 abstentions, motion passed.
Is there another motion we need?
Motion to move to the council.
You can do a favorable recommendation, no recommendation, or a non-favorable. Mr. Pullen has recommended a favorable recommendation.
I'd like to make a motion that we make a favorable recommendation to the city council for approval of this ordinance.
Second? Thank you. Roll call vote.
Roger Brock,
Yes.
Dean Button,
Yes.
Thank you.
Nathaniel Harris,
Yes.
Ann Herbert,
Yes.
William Hutton,
Yes.
Juan Moreno,
Yes.
Kimberly White,
Yes.
Janet Vanez.
Yes.
8 ayes, 0 nays, 0 abstentions, motion passed.
Thank you very much. Any correspondence? Sorry.
Okay, Mr. President, you know, we did, we have to do something with 1607. The petitioner is not here, and I would just suggest that we table that to the next meeting.
Motion, please.
So
Table.
move. Second.
Roll call vote. Oh, sorry.
For comment, actually. I would just like to point out staff's recommendation, or made a recommendation in their report that, be referred to engineering regarding drainage on the site. We have reviewed it, and so in the future, engineering is acceptable to the, conditions on the report that, obviously we're taking this, that can be dealt with next.
We just don't want to forget that point. Thank you. Any other questions? Call the question, roll call vote?
Roger Brock,
Yes.
Gene Button,
Yes.
Nathaniel Harris,
Yes.
Ann Herbert. Yes. William Hutton,
Yes.
Juan Moreno.
Yes.
Kimberly White,
Yes.
Janet Banana.
Yes.
8 ayes, 0 nays, 0 abstentions, motion passed.
Thank you. Any correspondence?
In your packet, you were provided some correspondence from the Intermission Organization. This was sent to the Plan Commission about an event they're coming up, and it's just so you are aware of it.
Thank you. Any commissioner comments? Staff comments?
With the tabling of the, 1607, we will have an October meeting. The date of that is October 17th. If you know you're going to be out of town, please let the staff know as soon as you are able to.
Thank you. Are there any public comments?
October 17th.
Hearing none, is there a motion for adjournment?
Motion to adjourn.
All in favor?
Aye.